I hope the screen is visible to all of you. Okay, so today's class is on copyright. Copyright is a special type of IP that doesn't fall under other industrial properties. So there are, okay, I'll be taking this, I'll be talking about it later. There's a slide for that. As we have already studied, or we have already covered patent and maybe design and semiconductor IC layout design. We have covered those things and you have given your internal assessment also. So today's class is on copyright. If you see the Oxford Dictionary, it says that the exclusive and assignable legal right, the copyright is given to the originator for a fixed number of years to print, publish, perform, film, or record literary, artistic, or musical materials. Please remember, this is just for the sake of your understanding. We are not going to give any question on what Oxford Dictionary has to say about copyright. Why should copyright be protected? The protection provided by copyright, it gives the return to the writer, artist, designer, dramatist, musician, architect, and producers of sound recordings, cinematographic films, and computer software, and creates an atmosphere conducive to creativity, which induces them to create more and motivates others to create. I hope you understand that. Basically, it is to encourage the originality and creativity in people's mind. So this is one type of IP. There are 8 types of IPs, right? We have already discussed about it earlier. Patent was one of them. Copyright is one of them. But there is a certain difference. There's a subtle difference. I should say that among all the IPs, there are certain differences that you should remember to pass this course. Okay. So here another line is very economic and social development of a society is dependent on creativity. So that's why you need to encourage originality and creativity in the society. So that's what I was talking about, that there are 2 branches of IP. That means intellectual property. There are 2 branches of intellectual property. One is called industrial property, that consists of patent, design, trademark, semiconductor layout design, geographical indication, plant variety protection. All these things, they come under industrial property. And there is something else that is called copyright. So copyright does not come under industrial property. So this is something you need to remember. There is a term called intellectual property, right? IP. Under that, there are 2 kinds of things. One is industrial property and another is copyright. So this patent, design, blah, 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 everything comes under this industrial property, and copyright is separate. Copyright is a specific type of intellectual property that is not industrial property, that you need to remember. So copyright relates to literary and artistic creations such as books, music, painting, sculptures, films, technology-based works such as computer programs or electronic databases. You can get copyright for all these things. Okay. But this is not industrial property. That I'll give one question on. So slide number 4 is important. If you guys are listening, slide number 4, you mark it. Differences in the protection duration. Since the protection for invention, for example, patent was given for invention. Remember, if you remember, so patent was given, patent gives a monopoly right to exploit an idea, such protection in short duration. So for patent, you will get 20 years of monopoly. But for copyright, that protection term is quite long. Copyright prevents only unauthorized use of the expression of ideas. Duration of protection for copyright and related right is much longer than that of patent. So for patent, that is for 20 years from date of filing. What is the term of copyright? Copyright protection continues after the date of the author. So remember here, when we are talking about patent, we don't talk about whether the inventor is alive or not. And the term of patent is not dependent upon whether the inventor or the applicant or the owner is alive or not. That completely depends upon the fact when the patent application was filed. From that date, your patent term will be calculated for 20 years. Okay, but for copyright, it's different. For copyright, it depends upon the lifetime of the author. So that will be protected the time when the author is alive plus 60 years. In case of India, plus 60 years. So for example, if today I write a poem, that is my copyright. So as long as I am alive, it will be protected plus 60 more years. 60 more years, it will be protected in India. Okay. After the term is over, the work enters in public domain. What can be protected? So copyright, there's a huge number of things that you can protect under copyright. For example, literary or dramatic work, musical work, artistic work, cinematographic film, sound recording, photograph, computer generated work. Here are a few of the examples, I just took from somewhere. And for example, the Harry Potter book by J.K. Rowling. So that is her copyright. The book is her copyright as long as she is alive. And then in that country, it is author's life plus 50 years, but in our country, it is author's life plus 60 years. And there is a lot of other things like, some musical work, some photographic work, sculptures, and then painting. All these things will be copyright protected. Copyright protectable works. Here is a big list of copyright protectable works when I will be sharing this slide with you, so you can see all these things. Books, pamphlet, other writings, lecture, addresses, sermons, dramatic or dramatic musical works, choreographic works or entertainments in dumb show, musical composition with or without words. Uh, for example, this doesn't have any words, just a musical note, right? But it is still copyright protected. So here it is written musical composition with or without words. Then cinematographic works to which are assimilated works expressed by a process analogous to cinematography. Then drawing, painting, architecture, sculpture, engraving, or lithography, photographic works, applied art, illustration, maps, plans, sketches. There's a there's a huge number of things that you can protect under copyright. Then translation and adaptation, collections of literary or artistic works such as encyclopedia, all these things you can protect under copyright. So if I give the question that what we can protect under copyright, so you can see slide number 7 and 8. So these are the example of artistic work: painting, sculpture, drawing, diagram, some cartoon, chart, plan, engraving. All these things will come under artistic work. Then there's sound recording. The copyright in a sound recording covers the recording itself. Okay. It does not cover the music, lyrics, words, or other underlying content embodied in that recording. That lyrics will have a separate copyright. For example, somebody will write a song for a movie. That is his copyright or her copyright, whoever is writing that. Then somebody is recording that music, that song. Uh, somebody will uh, give some notes, musical notes to that lyrics. That way it will become a song, right? So that is another copyright. Then that will be recorded. So that recording itself is the sound recording of copyright that we are talking about here. Uh, so I think you can unmute yourself or you can write it in the chat box also. That can you think of any other works that are not referred to in the previous list of works but could still be protected? I think I should wait for your answer. If you are not able to unmute yourself, which is not very difficult, you have to click on one button. And if you can chat also, if you are not able to do that also, then I will be really disappointed because I'll understand that you are not listening. So if you can think of any other thing that you think can come under copyright, you can tell me or you can write it in the chat box. I'll be waiting for your reply. So Tulsi Mahalakshmi, you are, yes, you are right. Yes, you are right. Any other thing? I already started it today, so if I wait, I might become very late. So nobody else is listening. Only Tulsi Mahalakshmi answered something. Music lyrics was covered, I think. But okay. Thank you guys for your reply. I'll move on. I'm already late. These are the things that was not probably covered in earlier slides. That multimedia, video games, 3D printing, virtual reality show, the complete show itself, websites, etc. So there are a lot of things that can be protected, as I am telling over and over again. There are some treaties related to copyright in the world. The first one is Berne Convention. Next one is Universal Copyright Convention. Then the Agreement on Trade Related, that's the TRIPS, the full form of TRIPS. We have already studied it when I was talking about patents. Then WIPO Copyright Treaty. Then Marrakesh Treaty to facilitate access to published works for persons who are blind, visually impaired, or otherwise print disabled. This might be important for you. This might give one question. This Marrakesh Treaty, for what it is, because this is very special kind of treaty that facilitates the access of published work for blind, visually impaired, those people. Okay, so there is something important that you need to understand, that for copyright, if you only think about something that is not your copyright, you have to fix that idea in some kind of form. So if you think about one image that is in your mind, that is not your copyright. You have to draw it or you have to paint it. If you think about one story, you have to write it. If you think about one story and if you tell it to some friends, and tomorrow that friends come up with that story and that friends writes it down, so that will become his copyright. It doesn't matter whether you thought about it earlier or not, you have to write it down. You have to fix it. Then only it becomes your copyright. Okay, the idea is not enough. So fixation is needed in case of copyright. The ideas in the work do not need to be original, but the form of expression must be an original creation by the author. So as I said, that if you think about some story but you don't write it down, it's just in your head, and then one of your friends writes it down, so that becomes that person's copyright, because that has got his or her special expression, the way he is expressing, that is that copyright. Your whatever is there in your head is not a copyright. So nature of copyright, it protects the presentation of the ideas in tangible form. So it has to be written somewhere, it has to be drawn, and it has to be fixed in some kind of form. Otherwise, it's not a copyright. And so the idea is not copyright, not the idea itself. You can see it on your screen. There are some bundle of rights and it subsists automatically. Okay, so there is another important thing that about copyright. You should know that when you have an invention, you file for the patent application. If it is granted, then you get the patent, right? But in copyright, it's different. If you write something, automatically you get the copyright of it. But if you have to fight with somebody, if you have to sue somebody in court, then better get it registered. Otherwise, copyright will subsist automatically. The moment you fix it, the moment you write it down, moment you draw it or paint it, or any other of those things, if you are able to do it, that is your copyright. So you don't have to file application the way you file patent application. But if you need exact proof of that, if you think that that might lead to some legal battle later and you need to prove it in the courts, then it's always better to get it registered, copyright registration. Otherwise, it subsists automatically. Rights of reproduction, communication to the public, adaptation and translation. These are the bundle of rights. See here, the bundle of rights that you get. when you have a copyright. So what are those bundle of rights? These are the bundle of rights. So these also I can give for exam. So slide number 4, 7, 8, 15. These are important. Rights protected by copyright. There are two kinds of rights that can be protected. One is economic right, and that is called moral right. Economic right allows the right owners to derive financial reward, so they can get some money, they can generate some money out of it. What is the moral right? Allows the creators to take certain action to preserve and protect their link with the work. That is called moral right. So what is the moral right? The right to claim authorship of a work. Right of paternity of the right of attribution. That is called the right of paternity or the right of attribution. That is the legal terminology. The basic thing is the right to claim the authorship of that work. That comes under moral right. Then right to object any distortion or modification of that work. Okay. How can I give you an example? For example, if Leonardo da Vinci, if he was still alive, and if he still had that copyright on Mona Lisa today, if he had that, and if I am making, the Mona Lisa to smile even more, or I don't know, maybe I'm changing her hair, or maybe I'm distorting the work in some way, then that will be Leonardo da Vinci's moral right to object. So that is a right that will be there with the copyright creator, so that if anybody is distorting or modifying the work, so they can protest against it. That is called right of integrity. These are the legal terminology, this and this, but this is the meaning of that. This is the Copyright Act, the book 1957. I think in all my classes I give you the example of this universal book. So here I have given the PDF link also. If you are interested, you can just click on the link. I'll be sharing the slide later. Section 13 of that act, it talks about what are the kind of work in which copyright will be, for which copyright will be given. So those are original, literary, dramatic, musical, artistic work, cinematographic film, and sound recording. So these are the exact things that have been written in the Copyright Act of India. So this is the Copyright Act of India. Okay, this is another question I might give, that when the Copyright Act was enacted, that is 1957. You can see that on top of that book also. Then section 14 is the meaning of copyright. For literary, dramatic, or musical work, what is the copyright? What is the right that you get for literary, dramatic, or musical work is to reproduce the work, to issue copies of the work, to perform the work in the public, in case of, dramatic, to perform the work in the public, to make any cinematographic film or sound recording in respect of that work, to make any translation of that work, any adaptation of that work is your copyright. Whoever has got that copyright, whoever is the owner of that. For a computer program, all rights like literary, dramatic, and musical rights. So for a computer program, these rights will be there. Along with that, to sell or give on commercial, rental, or offer for sale. So this is the extra thing for a computer program. These are all covered in section 14 of Copyright Act 1957. For artistic work, to reproduce the work in any material form, to communicate the work to public, to issue copies of the work to the public, to include the work in cinematographic film, to make any adaptation of that work, to make a copy of the film, to sell or give on commercial rental or offer for sale, to communicate the film to public. All these are for cinematographic film. Then for sound recording, to make a copy of the film, to sell, give commercial rental or offer for sale, to communicate the film to public. So those are the rights, okay, what you get by having a copyright. If you go here, you can see literary, dramatic, musical, artistic work, then cinematographic film, then sound recording. Okay, so those are covered in this. This is cinematographic film, this is sound recording. Now, what are the remedies for copyright owner? If your copyright has been somebody else is using without taking your consent, so you can go after that person, you can file a lawsuit against that person. If you remember, for patent, there is no criminal remedy. Only civil remedies are there for patent and also for design. But for copyright, criminal remedies are there. So here you see, for copyright, you can have civil remedies. So you can appeal to the district court. You can start a suit in the district court, and injunction, damages. These are the way of remedies that you can get through civil remedies, anti-pillar order. Maybe you don't need to remember all these things, but this is just for the sake of your understanding, or if anybody is interested to go through it in a detail, so you can go through it. Then there are criminal remedies also that comes under section 63. So for criminal remedies, you can have imprisonment, so you can go to jail. Like if you have breached somebody's copyright, so it can cost you some money also, or you can go to jail also. It can, both can happen also. You can go to jail, you have to give money also. So be very, very careful about when you are copying somebody else's work. Then there are administrative remedies. For example, copyright board, you can approach in case of dispute. Border measure, it's called border measure. I'm sorry about that spelling here. Importation of infringed copies, confiscation of goods by custom authority at the border, airport. You can do all these things. This is covered under section 53. This is called border measure. Okay. The A is typo there. Then what are the related rights? Performers, broadcasting organization, they will have the related right. Performance right means these people, when they are performing, they will have their own right. Okay, you can see several kinds of performances here, including stand-up comedian performances, any musical artistic performances, dance, ballet, solo music, solo singing, solo dancing, all kinds of things. They will have their performance right. And what is broadcasting rights? Here I was talking about this, right? What is broadcasting right? For example, now this Cricket World Cup is going on, and these are the channels, they have their broadcasting right. When you want to watch that, you cannot just randomly open some channel and watch it. Some of the channel only will have that broadcasting right. Okay. And there's another example I have given, that the Chandrayaan-3, if you are an Indian, so you know about Chandrayaan-3, that that event. So National Geographic actually covered that, and also Disney Hotstar. So they had that broadcasting right. And for ICC World Cup, these are the channels, they have that broadcasting right. So tomorrow for the final, if you go to RK Beach and if you watch that, you see on what channel you are watching it. It must be on any of these things. Term of related rights. Again, if you are sleeping, I will remind, these are the related rights. These are the things that I just explained. So what are the term of related right? That is 50 years. Okay. I talked about copyright, that is 60 years plus the author's lifetime plus 60 years. Here for related rights, it is 50 years. Broadcasting right, broadcast reproduction rights shall subsist until 25 years from the beginning of the calendar year next following year in which the broadcast was made. Okay. So this is also important, 50 years and 25 years also you need to remember. Is it necessary to register a work to claim copyright? As I have already told you, no. Copyright is automatic. It does not require any formality. So without paying any money to anybody, you can have your own copyright. However, certificate of registration of copyright can be very useful if you are going after somebody, if you are filing a lawsuit somewhere in some court. So that certificate will be proof that that is your copyright, right? So that is a prima facie evidence in the court of law. Court will not listen to it that no, I did it. Court will not listen to it. They need some evidence, some prima facie evidence. So that your registration certificate will talk about that. That will give the evidence. Indian provision for protection of database right. There is no separate legislation in India. In Europe, European Union and Singapore, they have a separate legislation for database rights. Copyright to a database is protected under the Copyright Act itself and some of the provisions of Information Technology Act. Okay, IT Act is Information Technology Act, which deals with the protection and data along with penal provisions. And some of the, in some cases, Article 21 of Constitution, it can also protect the database right. The sweet and bro doctrine is observed in India. Maybe if you are interested about it, you can go through that. Or if you are not, just you can just ignore it. When you are studying Copyright Act in a much deeper level, then you can think about all these things. Exception. So there are some exception. When I told you that you have your copyright and someone is infringing it, infringing, I have used the term earlier also, infringing is you have some right, someone else is stepping into your zone without your consent. So those kind of activities are called infringement. Okay. So, but there are some exception in copyright also. For the purpose of research or private study, that will not be called as copyright infringement. So, what do I say? For example, I have one paper, I have written something, that is my own copyright. I have not published it with anybody, or I have not given the right to any publisher or anything. But you are also using my work in your research, just for doing your research only. You are not publishing it or earning money out of it. Then you are exempted from that. Okay. That will not fall under copyright infringement. If in teaching, for example, if I am teaching you and if I am taking somebody else's work, that is also not coming under copyright infringement because I'm teaching. So for teaching, for research, these things will not be called as copyright infringement. For criticism or review of something will not be called as copyright infringement. And for reporting of current events. So these are not infringement. Okay. Then here also some more things are there. For example, performance by an amateur club or society. Either performance is given to a non-paying audience, so they are not, generating money out of that. And making of sound recording of literary, dramatic, musical works under certain condition, that will also be exempted under certain condition. There are certain terms called fair use and fair deal. So when I told you about this for the purpose of research or private study and for teaching, that is not called copyright infringement. So those things are called fair use or fair deal. If your work is for educational purposes, that the way I told you, like when I'm teaching, if I'm taking somebody else's material also, that is also not coming under copyright infringement because I'm using it for educational purposes. Then the copyrighted material falls under the fair use provision or fair dealing provision. The fair use term is used in the US, fair deal term is used in European Union. We generally use the term fair deal. So those things will not be called as copyright infringement. Okay. A notice at the beginning or end of your production giving credit to copyright owners for their work is usually sufficient. So these are the things that I just told. The fair use term is used in the US. Fair dealing term is used in UK and Commonwealth countries. So we also use fair dealing. In European Union, they have enumerated exception. They have a lot of exception and limitation and 3-step test. You don't have to know about that. Now there was a real life case, copyright infringement case in Delhi University. That is called the Delhi University photocopy case. So what happened here is that, you know, okay, so Okay, so there was a disturbance. That's why I muted myself. Okay, so the Delhi University, you know what happened in this university also, or in every university in the world, what happens is that there will be in some reference book, there will be some book that is very costly and nobody's gonna buy it. So what they do is that they take some photocopy of that book, and maybe the photocopying agency is residing inside the university campus. So we go, we take the photocopy, we distribute the photocopy, and ultimately nobody buys the book. So what happens in this case is that University of Oxford and others, they had some book and they filed some copyright infringement case against this Rameshwari photocopy services. That Rameshwari photocopy services is situated inside the Delhi University campus. Okay, so they filed the copyright infringement case against them in 2012. However, uh, that case, University of Oxford lost it. They didn't win the case. And the court said that infringing the copyrights of the publication's material by photocopying, reproduction, distribution on a large scale, circulating. I'm sorry, this is the term that University of Oxford used, that infringing the copyrights of their publication material by photocopying, reproduction, and distribution on a large scale, because a lot of people, a lot of students are taking that photocopy, right, and circulating among students and teachers of the university. So that was their claim. And University of Delhi argued that Section 52(1) allows students and educational institutions to reproduce parts from any work for research or educational purposes. So that actually didn't come under copyright infringement. So this Rameshwari photocopy or whatever situating in Delhi University, they own the case. There are a lot of copyright infringement happening in movies. Here is just an example of that, because I just, you can find a lot of this kind of examples if you Google. So I have given just one example that was there in 2019. The left part is, if you are from India, you know about Bollywood and Hindi movie, and the right one, I'm not sure. It's not Hindi. I'm not sure. It's some movie that was highly copied from the movie on your left. Okay, so this right hand side, that movie is Sri Sai Ganesh production and others. They are the producer of that movie, and the left hand side is Yash Raj Films Private Limited. So you can see the poster also looks a lot similar. Maybe the dresses are different, but overall it is very similar. Court is of the view that the defendants have blatantly copied the fundamental, essential, and distinctive feature as well as the forms of expression of the plaintiff's claim. This is called plaintiff. Whoever is filing the copyright infringement suit, they are called plaintiff. So here Yash Raj Films is plaintiff, and this guy, this Sri Sai Ganesh production, is the defendant. So they have copied all these things. So that was the opinion of the court. And this is just one example. There are a hell lot of example on that. For example, all these movies are on your right. You can see, I'm sorry, on your left, you can see the Bang Bang movie was from Bollywood. It was completely copied from the Night and Day movie by this Tom Cruise movie. It was absolutely copied from that. And then this What Lies Beneath was copied in that Raz movie, that horror movie. And then Salam Namaste, that is copied from this movie. I forgot this Hugh Grant movie. What's the name? Anyway, so there's a big list of movies like that. There's a lot of copyright infringement cases like that. Then there is a different kind of copyright dispute that happened in the case of Three Idiots. If you have watched the movie Three Idiots, and if you have read the novel also, you can understand that movie is absolutely based on, I should not say absolutely, but it's pretty much based on that Five Point Someone book by Chetan Bhagat. But the name Chetan Bhagat was nowhere mentioned in that movie. They didn't even give him any credit. So Bhagat claimed that he was not given proper credit for the story, and the issue was widely discussed in the media also. However, the film's producer mentioned that it was only loosely based on the book and no legal action was pursued. So something like that also happens all the time, that some movie is based on some book, but they don't give the credit. So this is another example. This is one compulsory licensing in copyright. I'm not going into that. Okay, so that was all about I had to say about copyright, and then I'll talk about plagiarism because that is very important in case of academia. What's the time? Okay, I still have got some time. So I'll talk about plagiarism now. I am keeping these slides because most of the people I meet here call it as plagiarism. That's absolutely funny. The term is called plagiarism. Please, if you are taking my class, please pronounce it right. It's called plagiarism, not plagiarism. Okay? The G is pronounced as genuine, not Guinea. Genuine. That G here. Okay, so I have to tell it because everybody is listening to that plagiarism. I don't like it. So plagiarism policy under UGC norm, if you are in some university, your university is UGC regulated, you will have to follow the UGC regulation, UGC guidelines for plagiarism. You guys are from B.Tech, right? So you also will have some project that will have to submit to your department for, I think you guys are at third year, second semester. You guys also have some project, right? Or second year, third semester you are second year, third semester. Anyway, so when you are writing some project, most of the people, they try to copy it randomly from here and there without giving the proper credit to anybody. That has nothing to do with copyright infringement. This is called plagiarism. So please understand, this is called plagiarism. Zero tolerance policy on plagiarism has been taken by UGC. So if you are studying in this university, be very careful about your project report. If it is found to be plagiarized, you can be expelled also from your class. So be very careful. In case plagiarism is found, it would be brought under plagiarism disciplinary authority for necessary and maximum penalty. Okay. So what are the similarities of with any work? Absolutely not right. So level one, like you have your similarity to 10% to 40%. That is, the university generally will decide how much plagiarism they can allow, how much similarity percentage they can allow. In general, it is 10 to 12%. So that will be called as level one. Level two means 40 to 60% means a lot of similarity. Like you have mostly copied from that source without giving any proper credit to that source. And level 3 is similarity above 60% means you didn't do any work, you are just blatantly copying all the works from that source. That's why I always tell everybody who is taking my class, please cite. Whatever you are copying from somebody, you put it in the citation, you put it in the inverted comma. And when your dissertation, when your project is done, you put under references that from here I have taken it. No one is going to blame you for that. But if you don't give any credit for that, that will come under plagiarism. And UGC have a zero tolerance policy on plagiarism. So please understand that. When 10 words are taken from some established work, citation is essential. Citation means you cite it. Down, you write references. And what is the work? The title of the work. For example, if it is a book, the name of the book, the author name, the publisher, the year in which it is published. There is some format, in that way only you have to cite. But so if that is, if 10 words are taken, if the copied content reaches 40 words, then you put it in inverted comma. Okay, this is a very important slide for you guys to understand how you can pass this university system. If you are copying more than 40 words in a sentence from somebody, you have to put it in inverted comma. Even in the case of open site internet sources, more than 30% aggregate is found copied, the work shall not be considered for further proceeding. This is from UGC website. I have taken it. This is not my saying. I'm not saying it. So be very careful when you are giving your project report. So this is what, when I'm talking about citation here and when I'm talking about there are some specific formats for citation, what I mean is that this is one example of one paper I have just randomly taken. It happens to be my paper. I'm sorry about that. I have just randomly taken one paper. So how you cite it? In that paper, I have cited some of the people's work, right? So after reading that work only, I have done my own work. That is the idea behind citation. So how you cite it? For example, Agarwal is Ramdhani, whatever, their names are there. Up to here, their names are there. So first you write the names. This is one kind of format. This is one kind of citation. You write the names of the authors first, then the name of the paper. This is inclusivity, blah, 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 up to from India. This is the name of the paper. Then the journal name, Journal of Enterprising Communities. In that journal, this paper was published. The journal volume is 14. In the year 2020, it was published, and page number is 299. So like that, there are certain formats in that way you have to cite, but please cite in order to avoid plagiarism. Okay, it's very, very, very important when you are studying in academia. So I'm at the end of my lecture today. It's all about copyright and plagiarism. So these are the sources. When I'm talking a lot about please cite this, please cite that, and doing all these things, and I'm not giving any credit to anything from where I have taken all these slides, where I got the idea of taking all these slides. So these are the sources, for example, the most of the things are from the Copyright Act 1957. So, and then there is Handbook of Copyright Law, and you can go to this website also. This is our Indian Copyright Office website. If you have any question regarding copyright, if you wanna register your work, you can go to this website and you can see it for yourself. And then this is the plagiarism that I was talking about. So this is the thing, Consortium for Academic Research and Ethics here. It's under UGC. So these are all the things that I had to talk about today. Thank you for listening to me, and I'll stop my class right now. The next class will be on trade secret, starting from now. If you don't want one break, let me know if you want one break or not. So if I am audible, I wanted to know whether you want one break or not.
Good afternoon, everyone. It is echoing. Okay. Good afternoon, everyone. Hope everyone is back. So today we're gonna discuss about another intellectual property, which is a trade secret. So trade secret, like any confidential information that is valuable to your business. So for example, what is confidential information? If you want to understand what is trade secret, I'm explaining what is trade secret. Any confidential information that is valuable to your business. First, we need to understand what is confidential information. So any technical information or business information or financial information, you can keep it secret. So that can be protected as a trade secret. Trade secret can be anything, something like any technical information, business and finance information. Any confidential business information which provides an enterprise a competitive edge and is unknown to others. For example, if you want to protect your information under trade secrets, so first we need to know what kind of information you need to what kind of information is eligible for the trade secret. So any confidential business information which provides an enterprise. What is enterprise here? Any small, medium enterprise or any company. Uh, a competitive edge. Here competitive edge means when compared to other company, the information can give competitive edge over others. Like because of that information, your enterprise is ahead than other company. So that is called competitive edge and is unknown to others. And that kind of information should not be available to the public. So it should be unknown to others and it should be it should give the competitive edge. That means it should not competitive edge means, for example, if you take two companies, for example, mm, Ola and some other company. So some information which is giving a edge over other company, other normal company to the Ola. So that is called competitive edge. And enterprise means as I discussed earlier, like all kinds of company, farm, everything comes under enterprises. So technical information, business and financial information, this information can be keep it as secret. So that kind of information we can keep it as trade secrets. For example, what can be the technical information? Actually, I detailedly explained what can be a technical information and business and financial information, because as I said earlier, these kind of information you can keep it as trade secret. Trade secret is nothing but it is one kind of intellectual property. So there is no sui generis law, specific law for trade secrets, something like patent or copyright or trademark, but still with the common law, we will be able to protect trade secret information. What is the information? What kind of information we can protect? I explained here in this slide. And in detail, what is technical information? With example, I'm going to discuss in the next slide. For example, product formula and recipes. Example, if you take the secret formula for a popular soft drink like Coca-Cola is a classic example. So whatever so far Coca-Cola formula nobody knows because it is protected through trade secret. In US there is a sui generis law. There is a specific law. For example, for us in India, for patent to protect our invention, if it qualifies patentability and if it doesn't belongs to non-patentable subject matter, definitely you can apply for a patent and patent will get granted under the Patent Act 1970. So there is a specific law for that. So there is, but coming to the trade secrets, there is no specific law. There is no sui generis law, but still with the common law means uh, something like, uh, uh, so with the precedents or with the judicial decisions, we will develop a jurisprudence, like, we will, that is called common law. So whatever the precedent, for example, Supreme Court gives any decision or any court gives a decision, higher court, so that will be the law of the land. So with that information or with that doctrines, uh, based on that you can protect it, you can protect the trade secret. So what are the laws we can use to protect the trade secret, that we will be discussing in the next class. So there is no sui generis law for this. And this technical information, coming to the technical information, something like any manufacturing process, for example, in any company, some proprietary methods and techniques will be there. And if you take any product design, for example, in any software company, if you take, there is a product design will be there, that normally they keep it in confidential, they keep it confidential. And also computer code, you might be joining in some company and you might be developing in some software. So that software is proprietary of that company, that you have to keep it confidential. So because you all are software engineers, right? So before you join a company, every company will ask you to sign a non-disclosure agreement or confidentiality agreement. All these agreements, they will ask you to keep the information, whatever the information, which is whatever the secret information, you have to keep it confidential. If you don't keep it, if you don't protect that information, so we will sue you by using the trade secret law. By in India, we don't have any sui generis law. We have to protect through common law. Common law, under common law, what are the acts will come, we will discuss. So this is very important for you guys. You need to know that before you join in any software company or any other company for that matter, you guys will be signing non-disclosure agreement. You are not supposed, even if you leave the company also, still you will be joining directly into some competitor company. Some companies will ask non-disclosure agreement and confidential agreement that if you are working in this company, you are not supposed to join in any competitor company when you leave this company next 6 months. So 6 months time they will ask, and after that you can join into competitor company. For example, before you join into any company, they will ask you to sign. You are not supposed to join in any competitor company. Or if you join also, you are not supposed to disclose whatever the confidential information you learned in this company. So all these kind of agreements you will be signing before you join into a company. So these all are will be protected through trade secrets. So like that, other examples are, I told coming to the technical information, manufacturing process and biotechnology process, research and development data, any information which is proprietary to that, and if they feel that this information is like any confidential business information to a specific enterprise, that means a company, and which can give a competitive advantage, and which is not available to the public, yes, definitely these things can be protected under trade secret. So another kind of information is business and financial information. I have given some other example for your reference. This is technical information, business and technical information. So customer list and consumer preferences, even consumer preferences also for some companies, for example, like KFC or some other enterprise, they will maintain some consumer preferences list. That information also will be protected through trade secrets. So pricing information, what kind of price you need to keep, marketing and business plans, all this sales and distribution channels, what kind of sales and distribution channel this product should go, or we should buy this product. This is all confidential information to that enterprise or a company. So that also can be protected through trade secrets. Even intellectual property strategies also, what kind of strategy that company is using, that also protected. For example, you join in a company, for example, you got an offer in a Google and happily you joined. You came to know some of the proprietary information. Before you enter into the Google, you might have signed a non-disclosure agreement or some confidential or some agreements. Okay, based on that, you are not supposed to disclose. If you disclose it, uh, you will be sued under common law, because trade secrets are protected through common law. So under common law, what are the acts that will cover? What kind of infringement provisions are available? That we'll be discussing in the next slide. What qualifies as a trade secret? So I explained, right, what kind of information and all. Business or financial information or technical information. So it should be commercially valuable because it is a secret. So whatever the information, you can keep it secret, but that information should be commercially valuable, because that information is very important to that enterprise or company. And this commercial, it should be commercially valuable. Then only the trade secret law will apply on that. I mean, it qualifies for a trade secret. So there is no sui generis law for a trade secret, and be known only to a limited group of persons. So the information, whatever the information we discussed here, this information should be known to limited group of persons. For example, some employees uh, join into some company, so they will be signing some NDA or some confidentiality agreement. and those limited people only will come to know. If it should not be available to the public, or it should not be available to known to everyone, then that kind of information cannot qualify for the trade secret. And the third one is reasonable steps taken by the rightful owner of the information to keep it secret, including the use of confidentiality agreements for business partners and employees. That is what they are saying. If you say that my trade secret information got violated by some employee, if imagine you are employer and some employee joined and says that my trade secret information got disclosed by somebody else, some employee, so I wanted to take action on the action on them. Make sure that you should take reasonable steps. You should take as an employer, you should take, and you should protect your information to keep it secret. That as an employer you should do. Then only it qualifies as a trade secret. For example, that's the reason most of the employers, when you join into that company, they will ask you to sign all these agreements of confidentiality, because their information tomorrow, if it violates, or if you disclose that information to competitor, or you can start that company, similar company, or while you are working with that company, you can share that information to somebody. They can take action against you. So for that reason, they are taking all these agreements like NDA or confidentiality agreement, because it should qualify as a trade secret. So if I summarize, it should be commercially valuable, whatever the information that should be protected through trade secret. These are the information: business, financial information, or technical information, and be known only to a limited group of persons, and reasonable steps taken by the rightful holder of the information. For example, here rightful holder is some company or some enterprise. He should take some reasonable steps, asking all the employees who are joining newly or already existing employees, they should sign some NDA, some agreements, confidentiality agreements, and make sure they have to take some steps to keep it secret. So then only it is eligible for trade secret protection. So famous trade secrets are, for example, if you take Google algorithm, nobody knows. If they know, even you can start one search engine. So that algorithm is protected through trade secrets. And McDonald's Big Mac recipe. So whatever the recipe they have come up with, even Coca-Cola recipe. Coca-Cola, it has been there in the market more than 100 years. Still nobody knows the recipe. And KFC recipe. All these recipes they are commercially valuable, and that recipes are known to only a limited group of persons, something like some employees of that company or somebody. And reasonable steps taken, all the employees or whoever knows that trade secret, they might have signed some confidential agreement, or some steps employer might have taken to keep it confidential. So these are all are examples of trade secrets. Google, McDonald's, KFC, and Coca-Cola. So now my question is, like, already we have patents, we can and we have trade secret. So which one we have to choose? For example, I have some information which is commercially valuable, and that kind of information which is giving a competitive advantage over others, and it is known to only limited number of people, and I have taken steps to protect that information. And whether I wanted to go for the trade secret or patents, how do you decide? So already we have patents, right? So why do you want to go for trade secrets? Because but we should understand the difference between the patents and trade secrets. Coming to the patents, scope of protection is limited subject matter. See, I explained in trade secrets, like the information is like technical information, any kind of technical information which can be commercially useful, or business and financial information which is commercially valuable. So that information can be protected. But coming to the patents, so it should be invention, it should satisfy the patentability, and it should not fall into non-patentable subject matter. So if you satisfy these conditions, then only you can protect that one through by using the patents. For example, if Coca-Cola had been protected through patents, it would have been in public domain by this time, and we would have been having several drinks like Coca-Cola or some different brands of similar Coca-Cola products. Because Coca-Cola have chosen to protect through trade secret rather than the patent. So that is the judgment. It all depends upon whether you wanted to uh, run the business for years or that. For example, Coca-Cola, I told, right, they have chosen the trade secret because they wanted to sustain in after 20 years or 50 or 100 years. So coming to the patents, a limited subject matter, like only few things only you can protect the patents. But trade secret, it's not like that. Whatever the previous slides I have discussed about what kind of information it can be protected, all that information can be protected through trade secret, provided if you satisfy the three conditions which I discussed in the last slide. So, and term of protection also, patent is just 20 years, but coming to the trade secret, it is indefinite. The secrecy is maintained of your information, which is commercially valuable and which is not available to the public. So definitely, as long as you maintain that, and definitely trade secrets, there is no term of protection. It will be indefinite. Procedure formalities, registration is required. And coming to the trade secret, no registration is required. As long as you keep it secret, that is trade secret. And in India, there is no sui generis law. There is no explicit law for that. And through common law, we protect trade secrets. And that's the reason when employee joins in a company, when somebody joins in a company, employer will ask some documents to keep the information secret. So whenever that is violated or employee disclose that information, then employer can take action on that by using common law. That's the reason no registration is required. Type of protection, exclusive rights are granted and protection against infringement. So what are the exclusive rights for the patent? You can exclude others, that is a negative right. You can exclude others from making, using, selling, so importing, etc. So these kind of exclusive rights will be given to patents. Here coming to trade secrets, it's something like as long as you are keeping secrecy, you are maintaining your secrecy, then trade secrets are protected and no exclusive rights are granted for that. And protection is only against misappropriation. What is misappropriation? We will discuss with several examples. And coming to the disclosure, yes, disclosure is required. After 18 months, automatically it will be published. If it is a proactive publication, within 1 month it will get published. And coming to the trade secret, not required, and you are not supposed to disclose, because once it is disclosed or known to the public, that's it, your trade secret is gone. And if you disclose by yourself, it's gone completely. So, and coming to the cost, expensive to file and process. Obviously, patent is a expensive fund. So trade secrets, this is comparatively low, because just like some non-disclosure agreement or confidentiality agreement or some other agreements, you can make sure that the information is secret and it is not disclosed to anyone, and that information is valuable. If you can maintain that, that's more than enough to protect the trade secrets. And cost, expense, coming to the time, complete production may take years, normally 3 to 4 years. If patents, if you file, since from the filing it will take some time to get the grant. And coming to the trade secrets, immediately effective. The moment you the moment you secure a non-disclosure agreement or whatever may be, confidentiality agreement and all, and if that is a valuable information and it is not available to the public domain, and if some employee joins and if he try to disclose that information to somebody else, immediately you can take action on them by using the common law. The next one is how trade secret can be lost. For example, I have told, so when you can sue others. Now here, if a single unprotected disclosure may result in loss of trade secret. For example, some employee somebody joined in your company as an employee, and you didn't take as an employer, you didn't sign NDA or confidential agreement, and you didn't protect anything, through any mechanism, you didn't protect that information, and you can disclose to somebody else, and you cannot take any action on them because you did not take any steps to protect that information. So in that case, you cannot you cannot claim for the trade secret. And another one is legal reverse engineering of a product to discover the trade secret. For example, you take some product and properly, if you can reverse engineer it, and if you can find out that this is the actual process, like how they have come up with, and if it is that process is legal, yes, definitely, you cannot claim through trade secret. And independent development by a competitor. So if competitor by his own, if he can come up with mm, if he can come up with that product or process or whatever may be that has been protected through trade secret, then definitely in these three cases you cannot claim through trade secret because uh, because it is first case it is unprotected, and second case it is reverse engineered, like properly through legal process it is reverse engineered. So definitely you cannot claim through trade secret. And next one is some competitor he has come up with by his own. Though you sue also, if you can prove that it is independently developed, then definitely you cannot claim through trade secret. And your trade secret is, of course, it will be lost. So normally for every intellectual property, like from patent, copyright, trademark, semiconductor, PVP, like that, each and every IP, there is some standard, international standards, some jurisprudence is there with respect to international standards. So coming to this trade secrets, so the mention of Article 10B of the Paris Convention and Article 39 of 2 and 39.3 of the TRIPS agreement. So this is very important, Article 39 of the TRIPS agreement. I told earlier what is TRIPS agreement, trade related aspects of intellectual property. This is the international multilateral agreement, like almost all WTO countries, World Trade Organization countries are obliged to sign on this multilateral agreement, which is the TRIPS agreement. So this is like this TRIPS agreement is like minimum standards with respect to intellectual property, minimum standards that should be available to each and every country. So everybody should comply with the TRIPS. So these international standards, which is Article 39.2 and 39.3 has been mentioned in the TRIPS agreement, and every country should comply with that. Every country which is the member of WTO, World Trade Organization, almost more than 190 countries are part of the World Trade Organization. So all the countries has to comply with 39.2 and 39.3. Based on that, they can come up with they have to protect the trade secrets by using their by using the common law. If countries like India, or they can come up with sui generis law. For example, if you take a US, United States of America, there they have come up with a sui generis law. They specially enacted for the trade secrets. And what are the if somebody violates, what kind of recourse you can take, and corresponding infringement, corresponding damage, everything. There is a statutory law which is approved in their parliament, and so as per the TRIPS agreement, everybody has to protect trade secret. So that how you gonna protect the specific country, how the specific country is going to protect it, all depends upon that country. So coming to the India, we have not enacted any sui generis law, specific statutory law, which should be approved in the parliament. So we are protecting through common law. I will discuss what is common law, what is the tab common law. These international agreements set standards for the protection of trade secret and intellectual property rights. Because this we are compliant to TRIPS agreement, we are also part of WTO in that 190 countries. And even Article Paris Convention also in Article 10B, this is the first convention that has been enacted, Article 10B. With respect to intellectual property, Article 10B of the Paris Convention. So protecting trade secrets in India, as I discussed earlier, there is no dedicated law in India, unlike US, and enforced through contract law. I'm keep on using the common law. common law is nothing but like that is not a statutory law. Something like, the law is enacted. I mean, some bill is drafted and that is enacted in the parliament and get the consent of the president, and then it became an act. So there is nothing like that. There is no statutory law for the trade secret. Unlike, patent act and, copyright, trademark and semiconductor integrated circuit layout, like that. So, but there is a common law. What is common law? Common law is nothing but through precedents or through judicial decisions, uh, that due to that decisions and precedents that become act. For example, Supreme Court gives any decisions, that will be the law of the land. So due to and based on the doctrines and principles, that has a ground in the court, and based on that, court will accept it. For example, if your trade secret is violated, you can take the recourse or you can sue them by using, there are under common law, contract law, under common law or contract law, Indian Contract 1872, that is the act, or principles of equity, or by common law. By using these things, you can protect your trade secret. I told what is common law through judicial precedents and judicial decisions and precedents, and Indian Contract Act, because for example, there is a franchise. For example, in Vizag, there is a what is that biryani? Some Paradise, yeah. So Paradise is there in Hyderabad, and Paradise is there in Vizag. So actually, this is the franchise one, but they will be having exactly like Paradise symbol and everything. So they might be having some contracts between them, like with the Hyderabad one and Vizag one. Vizag, some two, three Paradise outlets are there, I guess. So actually they are franchise. The Hyderabad one will be having some contract with them, and they have to keep confidential some trade secret, like, how to come up with, how to prepare that kind of biryani, and how to get the texture and all that. They might have protected through some contract, some agreement. So that will be protected through Indian Contract Act, apart from this common law. And principles of equity. What is this principles of equity? Equity means if you can principles of equity is nothing but justice. So if it is not a natural justice, even then based on that you can file a case in the court. And also offenses such as criminal breach of trust, theft or cheating may be applicable. For example, you joined in a company and you have stolen some information from your office, or uh, uh, you you copy some information and given to some competitor and got some lump sum amount. All these things are comes under criminal breach. So this is all violations of the trade secret. So coming to protection under contract law, we are discussing about how to protect a trade secret, because trade secret, if it violates, what kind of recourse we have in India through common law or contract law or principles of equity. So protection under contract law. So for example, section 27 of the Indian Contract Act address the protection of trade secrets through principles of equity and contractual obligation. So if I take example, so it will be easy to understand. An employee signs a contract with a company agreeing not to disclose any confidential information related to the company's trade secret during or after employment. So it's not only during, even after employment also you are not supposed to disclose. The contract may include a reasonable restraint clause ensuring that the employee does not use or disclose such information after leaving the company service. So if the employer come to know that the employee discloses even after the employment, still he can take the recourse by using contract law. So another example is uh, uh, remedies for infringement as well. For example, if anybody infringes, that means remedies for trade secret infringement may include seeking injunctions or damages. I will explain what is injunction damage. Injunction means court can give the order that you stop producing it or something like that, so that the further damage, so that it can stop the further damage. That is called court is having power to give the injunction, like order that further to stop something or to produce something. So our damages, whatever the damages you get it due to disclosing trade secret information, or uh, so that is called damages. The Specific Relief Act 1877 governs the granting of injunctions, requiring the establishment of a prima facie case, a balance of convenience and the presence of irreparable loss. So, apart from contract law, even there are some remedies in Specific Relief Act 1877. I will take one example so that it will be easy for you. A company discovers that a former employee, he is not the current employee, he is a former employee, has a misappropriated trade secret. What is misappropriation here? Trade secret, and is using them to benefit a competitor. The company seeks an injunction from the court to prevent the ex-employee from continuing such activities, because ex-employer discloses some information to the competitor and he got some lump sum. Okay, if he still continue, it is definitely some damage. It will incur some damage to the current employer. So, for that reason, injunction has been issued, and from continuing such activities, and may also claim damages for any loss incurred, and also whatever because this information has been shared to uh, shared by ex-employee, right, in the current company. So definitely damages also can be claimed. So I'm just explaining what are the remedies for the infringement by using several Contract Act or Specific Relief Act. And there is a real-time case in India, though we don't have sui generis law, how our Indian courts are protecting trade secrets. So don't think that there is no sui generis law, there is no statutory law. Statute means through parliament. Follow the bill become act, parliament approves, and because there is no sui generis law, don't think that trade secrets cannot be protected and I can breach the confidentiality or privacy, breach the confidentiality agreements and all. Please don't think like that, because there is a already Indian case how they protected trade secrets. We are explaining through this case. I'm just giving some example. So coming to the background, in the case of John Richard Brady, he is the plaintiff, and chemical process equipment, he is the defendant. The Delhi High Court was faced with a situation involving the unauthorized use of trade secret. So the case highlights the Indian court's commitment to protecting trade secret under common law. So under common law, how we are protecting? Why this is trade secrets are very important, because most of the work, even for you guys are students of computer science, right? So most of the work you guys are getting from offshore work, like from US, some company established in India, and whatever the work they wanted to get it done for a cheap price, they will get it done in India. That is called offshore work. So most of the companies in India, consultancy companies, are there offshore only. They get the work done in India because it is very less expensive for them to get the work done from India when compared to US. So to establish some companies in India, some software companies, something like TCS, Infosys, HCL, or whatever may be. So our country also should provide some complaint, intellectual property complaint laws. That's the reason trade secret also, it's very important. If you don't protect trade secret properly, definitely those companies cannot come, because the uh, for example, in TCS, if somebody joins and if you disclose all the information which is related to some US company, something like Google or Cisco or whatever may be, because so many offshore development center, you can find it in India only, which is managed by these consultancy companies, starting from TCS, Infosys, and HCL. So they establish companies here because we provide protection for the proper intellectual property. So as part of the trade secret is very important. Uh, so here, chemical process equipment, actually they violated a trade secret. How our Indian courts are, by using the common law, how we are handling this, that we are discussing in this case. So facts of the case is John Richard Brady and others here the plaintiffs were involved in a legal dispute with chemical process equipment. So they are defendants. So the plaintiff alleged that defendants had engaged in the unauthorized use of trade secret, specifically related to the plaintiff's fodder production unit. So they might be having some agreement with the defendants, and these defendants violate some specific confidentiality information, and that has been disclosed. And because of that, this plaintiff approached the court. The information in question had been entrusted to the defendants under explicit conditions of strict confidentiality. So whatever the information that plaintiff is sharing to the chemical process equipment, which is a defendant, that information is explicitly protected. So that means to get the eligibility that information is information should be protected under trade secret, it should be confidential, it should be known to some people, it should not be available to the public domain. So this satisfies these conditions. And coming to the key legal points and rulings, so breach of confidentiality. Here plaintiff might be having some know-how information or specifications, everything they might have shared to the defendant under explicit conditions of strict confidentiality. So this information has been shared, and this information has been misused by the defendants. So for that reason, that has been proved in this case, and that's the reason court has given the injunction and corresponding damages. And so in this case, significance. What is the significance of this case? This case is notable for emphasizing the role of common law in protecting trade secrets in India. Though we don't have sui generis law, through common law, we are protecting the trade secret. The court decision to grant an injunction reflects a proactive approach to prevent the misuse of confidential information. If the court don't give an injunction to the defendant, so definitely it is a damage for the plaintiff. So court proactively gave the injunction to stop further damage to the plaintiff, as they are not compliant with the trade secret agreement with the plaintiff. So the ruling reinforces the principle that even in the absence of specific legislation, like sui generis law, Indian courts are willing to use existing legal frameworks to protect trade secrets and ensure a fair competitive landscape. So because we are providing protection of trade secrets effectively, even though there is no sui generis law or specific legislation, since we are able to protect it and ensure a fair competitive landscape. That's the reason some companies are coming and investing in our country, as we are providing a enforcement mechanism very effectively. That's the reason our country GDP is also growing really well. So definitely IPRs will contribute to the GDP as well. In summary, John Richard Brady versus Chemical Process Equipment exemplifies the Indian judiciary dedication to address trade secret misappropriation. Misappropriation means they breach the confidentiality agreement. Through common law, I discuss what is common law principles and highlight the importance of protecting confidentiality information. If you don't protect, people won't come and invest in our country. If it is a trade secret, or if it, for the matter, if any intellectual property. So these are the reliable resources. You can go and search, which is a WIPO, trade secrets. This is not specific to the Indian law. This is like what are the international treaties are available with respect to trade secrets, and if any information that has to be protected through trade secret, what are the conditions that needs to be satisfied. All that information, it is available. General information, it is available. It's not specific to any country. And thank you so much. If you have any questions, you can ask me.